Welcome back. In this subunit, we're going to discuss the very special case of quasi-contracts. Now, I know this is a course on contracts, and I know I just said that this subunit is on quasi-contracts, but quasi-contract is not really a contract at all. We teach quasi-contracts in the contracts course because it is a very close cousin to contracts. All right. Let's begin our discussion of quasi-contract. Now first, quasi-contract is a name, but it may go by other names. So sometimes you will see quasi-contract referred to as a contract implied in law. And you might say, wow, Chris, we already talked about implied contracts. How is this different? Well, the implied contracts that we talked about in previous subunits, those were implied in fact contracts. Those were actual contracts that were formed by the conduct of the parties. A contract implied in law is not a real contract. Anytime you see something saying in law, a contract implied in law, what it means is that it's not really a contract, but the law is going to consider it a contract, an obligation for this particular case. Sometimes quasi-contract comes under the name of unjust enrichment. And sometimes it comes under the name of restitution. And sometimes it even comes under the name of quantum meruit. Now, throughout the course, I will try and use the term quasi-contract and not these other terms. But sometimes I'll slip and I'll use one of these other terms. Or if you're reading a case or you're reading a text and they use one of these other terms, you know that they are referring to quasi-contract. Now, the most important aspect of quasi-contracts, and we've already mentioned it several times, is that a quasi-contract is not really a contract. Okay? Why is it not a contract? Well, it's not based on the agreement between the parties. Let's look at an example of a fact pattern that implicates quasi-contract. All right, so imagine homeowner A hires contractor to build a patio in homeowner A's backyard. But by mistake, contractor builds the patio in homeowner B's backyard. Contractor wants homeowner B to pay for the patio. Well, is homeowner B required to pay for the patio? Let's think about contract. Is there a contract between homeowner B and the contractor to build a patio? No, we have no contract. So if contractor wants to be paid for the patio he built in homeowner B's backyard, contractor cannot sue in contract. Now, contractor will sue in quasi-contract, and let's discuss whether contractor has a good case. Let's talk about whether contractor has a good claim against homeowner B under quasi-contract. Now, whether contractor has a good claim against homeowner B really depends on the law and naturally the facts of the case. So the law of quasi-contract is that a party can recover under quasi-contract if she conferred a benefit on the other party and it would be inequitable for the other party to keep the benefit without paying for it. Now, in our example, what we're asking is whether contractor conferred a benefit on homeowner B and whether it would be inequitable to allow homeowner B to keep the benefit without paying for it. Now, here we have a very good argument that contractor conferred a benefit on homeowner B, right? Homeowner B now has a patio in her backyard. And we can speculate that it's a nice patio and that it raises the value of her property. Okay? So now we go to the second element of quasi-contract. And so the question now is, would it be inequitable to allow homeowner B to keep that patio, to keep the benefit without paying the contractor for it? Now, you look at that word inequitable. And simply what inequitable means is it fair? Inequitable is just another word for fairness. So you're looking at this doctrine and you see this doctrine is not based on contract. It's not based on an agreement between the parties. It's based on fairness. And anytime we're talking about fairness, fairness is a very vague term. So hopefully the law gives us some sort of standard to determine what is fair. All right, so now the issue we are discussing is whether it would be inequitable to allow homeowner B to keep the benefit, the patio, without paying contractor for it. And we said inequitable is a very vague term. The term fairness, very vague. So does the law give us any standards to look at? Now, first, let me just say, anytime you're doing an analysis of equity or fairness, it's very fact specific. But in this case, we have a couple factors that we want to look at when we're determining whether it would be inequitable for the person who received the benefit to keep it without paying for it. And the first factor we want to look at is whether the person who conferred the benefit, in this case the contractor, was intending to make a gift. Did contractor confer the benefit to homeowner B gratuitously? Was it a gift? Now, this is the reasoning. If contractor was making a gift to homeowner B, then it's reasonable for homeowner B, it's equitable, I should say, for homeowner B to keep that benefit without paying for it, right? If you receive a gift, you don't pay for it. All right, so that's the first question. Now, in this case, what do the facts indicate? Well, the facts indicate that the contractor was not making a gift to homeowner B. Contractor went on homeowner B's land by mistake. And we have nothing in the facts that indicate that contractor was intending to make a gift to homeowner B. Now, the second factor we want to consider is whether the party who conferred the benefit did it officiously. And you might say, what does officiously mean? Well, it means, were they acting in an intrusive manner? Right? Now, the question here is whether contractor was acting in an intrusive manner. If contractor is acting in an intrusive manner, is acting officiously, then it is equitable for homeowner B to keep the benefit, to keep the patio without paying contractor for this. Now, in this case, we have arguments both ways that that contractor was acting officiously. Of course, homeowner would say, listen, you came onto my land without permission, and therefore you are acting officiously. And the contractor would say, well, I came on your land, but it was by mistake, and so I wasn't acting officiously, right? Maybe we need some more facts, but at least right now we understand the two issues that you need to explore when you're answering the question, is it inequitable for us to allow the homeowner B to keep the benefit without paying contractor? Let's talk about another situation that often implicates quasi-contract, right? This is the situation where one party administers emergency aid to another party or rescues that party. Let's look at a fact pattern, all right? Let's imagine that Mary is hiking and she sees Bob hanging by a branch and Bob is about to fall to his death. Now, at risk to her own life, Mary saves Bob. The question is, can Mary now say to Bob, well, Bob, I saved your life, please pay me? Now, there was no contract between the parties, so Mary's only possible cause of action is under quasi-contract. Now, remember, quasi-contract requires that one party confers a benefit on the other party. And in this case, clearly, Mary conferred a benefit on Bob. Mary saved Bob's life, right? Then our second question is, would it be inequitable to allow Bob to keep this benefit without paying Mary for it, right? And once again, this term inequitable, it's about fairness, it's very vague, but we know to look at a couple things. So first, let's look at whether Mary conferred this benefit on Bob officiously. If Mary conferred the benefit on Bob officiously, then it is equitable, it is fair to allow Bob to keep the benefit without paying Mary. Now here, Mary saved Bob's life. It wasn't like she was butting in where she didn't belong. It wasn't like she was acting intrusively. So we'll say that Mary did not act officiously. The second question we have to ask is whether Mary acted gratuitously when she saved Bob. Was she making a gift to Bob? Was she doing it out of the goodness of of her heart? And in this case, the law has an irrebuttable presumption that if you rescue someone, you are doing it out of the goodness of your own heart. You are acting gratuitously. And because of that, it's a gift. And if it's a gift, if you're acting gratuitously, then it is fair, it is equitable to allow the other party to keep the benefit without paying you. In this case, because Mary was acting gratuitously when she saved Bob, it is fair to allow Bob to keep the benefit of his life without paying Mary. Now, here's the fun thing. We can change the facts a little bit. Let's say Mary stumbles upon Bob and Bob is hanging there and Bob says, "Mary, save me. If you save me, I will pay you $2,000. And Mary says, "Okay," and saves him. Now we have an express contract. We don't need to go to quasi-contract. Bob is bound to pay Mary under the doctrine of express contract. All right, let's further explore this idea of emergency aid and rescue and whether a party who administers emergency aid or rescues another person can recover from that person under quasi-contract. Now, in this case, we're going to give a little hypothetical. And in that hypothetical, we're going to make a couple important changes to the facts. So here's the first important change of the facts. A physician, a licensed physician, is out for her evening walk. And she runs across Mary. And Mary is having some sort of medical emergency. And Mary is unable to respond. And so the physician administers medical aid to Mary. Once again, this is just the situation of administering emergency aid or rescuing a person. Can the physician recover under quasi-contract? Well, you remember our elements of quasi-contract. There had to be a benefit conferred. Here, the physician conferred a benefit on Mary by administering aid to her. The second question is, would it be inequitable for us to allow Mary to keep that benefit without paying the physician for it? And the first question we asked, of course, was it officious for the physician to administer the aid? And I think we agree here that it wasn't officious. It wasn't like the physician was butting in where she didn't belong or acting intrusively. All right, so we solved that problem. The second question is whether the physician acted gratuitously in providing that aid to Mary. Now, in the previous discussion, we said that there is I said, not you. I said that there is an irrebuttable presumption that when you rescue someone that you are acting gratuitously. And it is rebuttable, but it's rebuttable in one situation only. And this is when it's rebuttable. When you volunteer to provide aid to someone, you are acting gratuitously unless, number one, you are qualified by license or profession to give that kind of aid, and two, that you intended to charge for that aid. Now here, in this case, we have a licensed physician who administered medical aid to Mary, so it qualifies under that first element. The second element is more factual. Did the physician intend to charge Mary when she administered the medical aid to her? This is factual. So on an exam or in real life, you are looking for facts that would either indicate that the physician did act with the intent to charge Mary for her medical services or was acting gratuitously. All right, here are some final notes about quasi-contract. You might be asking yourself, in this course, when will we actually run across quasi-contract? Well, we'll run across it as a secondary argument. Your primary argument is contract, right? If you can recover from the other party under a cause of action for contract, you will use that cause of action. But if that argument fails, you will argue quasi-contract as a secondary, as a fallback argument. Here's an example. Let's assume that the parties enter into an oral contract. Now, we have said up till now that oral contracts are as enforceable as written contracts. But later in the semester, we'll find out that there are a small category of contracts that must be in writing. And if they're not written down, if they are oral, a court will not enforce that contract. So let's assume that that's the case here. We have an oral contract, but the law requires it to be in writing. So now it's an unenforceable contract. Let's assume, though, one of the parties, we'll call it Party A. Party A performs under the contract. Well, we have performance, but we have an unenforceable contract. So Party A would like to recover from Party B, but Party A cannot use a cause of action in contract to recover from Party B. What's Party A's fallback argument? Well, Party A's fallback argument, Party A's secondary argument is a cause of action under quasi-contract. So Party A says, I conferred a benefit on Party B because I performed my obligations under the contract. And it would be inequitable to allow Party B to keep the benefit without paying me. Why? Number one, I did not act officiously. I was acting under a contract, even though it was unenforceable. So I was not acting intrusively, officiously. And I was not acting gratuitously. Clearly the facts indicate that I was not intending to make a gift to Party B because we had a contract. And even though that contract is unenforceable, it is evidence that Party A was not intending to make a gift to Party B. Let's review what we've learned in this subunit. We introduced the idea of a quasi-contract. We gave other names for quasi-contract, including contract implied in law, restitution, quantum meruit, and unjust enrichment. We made clear to point out that quasi-contract is a misnomer. Even though it has the word contract in it, it is not a contract. Why? Because it's not based on an agreement between the parties. Right? What are the elements of quasi-contract? Well, we ask ourselves whether the party, the claimant, the party who wants to recover compensation from the other party, conferred a benefit on that other party. And the second question we want to ask is, would it be inequitable if we allowed the other party to keep the benefit without paying for it? We recognize that the term inequitable is a vague term. It just means fairness or unfairness. And so we needed to look at two other things to help us determine whether it would be inequitable to allow the other party to keep the benefit without paying for it. And we ask whether the party who conferred the benefit did it officiously. If the party conferring the benefit did it officiously, then it is fair for the other party to keep the benefit without paying for it. The second question we ask is whether the party who conferred the benefit did it gratuitously, as a gift. If the party who conferred a benefit did it as a gift, then it is equitable, it is fair to allow the other party to keep the benefit without paying for it. Now, we also discussed the rescue emergency aid situation. And generally, the law says that if you administer emergency aid or rescue someone, you are doing it gratuitously, and therefore you cannot recover under quasi-contract. But we did see an exception, and the exception usually comes up with physicians or other people who administer emergency medical aid, that they are not acting gratuitously if they are licensed to provide those services, licensed or qualified to provide those services, and they were doing it, they provided those services with the intent to be compensated. They did not intend to act gratuitously.